Okay.
We spoke to him earlier on this matter. Alhaji is a former member of parliament for Tamale Central. Let's leave it there. Alhaji, good morning.
Good morning. How are you?
I am fine. I hope you are too.
I'm good.
Great. What do you make of the decision of the judge in this case?
Well, I think that the applicants in the matter were able to, if one marks a matter that is essentially a constitutional matter in a motion that questioned the power of the special prosecutor to continue to prosecute, and led the court into arriving at a decision that borders on the interpretation of the Constitution, particularly Article 88, 3 and 4, and Section 4.2 of the Special Prosecutors Act, Act 959.
Is that a correct interpretation for you?
It's a problematic interpretation.
It's a problematic interpretation.
Yes. Because what the judge did was to read at Section 4.2 and juxtapose Section 4.2 with the constitutional provision that vests all criminal proceedings in the Attorney General or any person established by law, any person in accordance or institution in accordance with law. Now, to the mind of the judge, if an institution is established to prosecute, because all criminal offenses are vested in the Attorney General, it will require the Attorney General to give a fiat. For him, the prosecution of the case could not continue if the special prosecutor did not show evidence of the authority to prosecute on behalf of the Attorney General. And that is problematic. That ignores what Parliament did, or what Parliament was taken to do in 2017 when they passed the Special Prosecutors Act. Again, that seems to be blind to the fact that there is in the Supreme Court a pending action that is seeking to invalidate Act 595, Act 959, on the basis that Attorney General has not issued a fiat. Essentially, what the High Court did was to take a short-circuited route to what the Supreme Court has been invited to do.
But I'm guessing, and kindly correct me if I'm wrong, there are two powers that the Office of Special Prosecutor has: investigative, prosecutorial, right?
Yeah, and many others.
Many others. Okay. Now, what is challenging essentially has to do with the prosecutorial powers of the Office of Special Prosecutor and in what form he exercises it, right?
Yes.
Okay. Is it evident or apparent from the face of the law of the Office of a Special Prosecutor that fiat has been granted? Can I pick the law and tell that it has been granted?
That is what is in the Supreme Court. Is it the case that when you read the long title of the Act, and particularly Section 4.2 of Act 959, has the fiat of the Attorney General been statutorily given to the Office of the Special Prosecutor? And can Parliament statutorily give the fiat of the Attorney General to any other institution to prosecute in the name of the Attorney General? In other words, can Parliament circumscribe how the discretion of the Attorney General can be exercised?
Those are matters that go to, is it interpretation of the Constitution?
Yes.
Okay.
And that's why I thought that what the judge ought to have done was to refer the matter, even though the application was not for an interpretation of the Constitution, but the invocation of the power of the court to determine whether the special prosecutor was vested with the requisite authority to continue to prosecute the case.
So to you, what you expected him to do was to just refer it to the Supreme Court?
To unmark the application, to say, look, yes, I get your application. Your application seems to be inviting me to determine whether or not the special prosecutor has a fiat to prosecute. Now, if you unmark your application, it actually is seeking to interpret Article 88, 3 and 4 as against Section 4.2, and to strike out Section 4.2 as being unconstitutional. I don't have the power to do so. It's only the Supreme Court that can do so. So I'm referring this matter to the Supreme Court for determination.
Having said that, what then does the decision of the judge as we see it mean?
It's a decision of the court. The decision of the court. So no matter how erroneous that decision is, it remains in force until set aside.
Would it apply because I think the special prosecutor has other cases at other high court, in other, before other high court judges? Are they obliged to apply this decision?
No.
Okay.
The High Court of coordinate jurisdiction. And so they don't establish binding judicial precedent against a high court decision does not establish a binding judicial precedent against another high court. They are courts of coordinate jurisdiction. And so, I mean, they can look at the decision as a guide, but not binding on them.
So it means that another high court judge can decide to listen to a case that has been brought by the OSP.
Yes, another high court judge can decide that, oh, no, what the court has done, I don't think that is binding on me. I'm going to continue to listen to the case. I'm going to continue to hear this matter until the Supreme Court decides otherwise. But I had always said, immediately it came to my attention that the Damte had filed a suit in the court challenging the authority of the OSP to prosecute, and without a fiat, and that the Attorney General had somehow, in his response, sided with Damte. I was left with no doubt that the cases being prosecuted by the special prosecutor were mad in legal controversies. So what is happening doesn't come to me as a surprise at all as a lawyer.
Essentially, those of you who sat on the legislation, got it passed, among others, do you think you took actions that will protect the Office of Special Prosecutor when this matter comes for scrutiny? Because you're saying it is also at the Supreme Court, where there's an assessment of the prosecutorial independence of the OSP. Would it stand the test of the law?
Well, so it is safe for me to say that the Parliament, the 7th Parliament, that was considering the bill introduced in Parliament for the creation of the Office of the Special Prosecutor by the then Attorney General and Minister of Justice, Gloria Akufo, was left in no doubt. And if you go and look at the debate on policy, that is the second reading of the bill, you will see our interventions where we drew attention to the constitutional provisions and potential challenges to what we're trying to do. I remember during the debate, we all unanimously agreed, especially on the minority. I was in the ranking member representing my side. I was leading my side. Had said that the Attorney General had come to say that they were going to break the monopoly, the exercise of monopoly over prosecution of the Attorney General. I said, no, you can't do that. You can't break that monopoly. What you need to do, if you want to break the monopoly, is to bring a constitutional amendment, to sponsor a constitutional amendment to break the monopoly. But you can't use an act of parliament to break the monopoly. Now, Guinea also referred to Section 4.2 and said that appeared to be inconsistent with the Article 88, 3 and 4 of the Constitution, and that something substantial had to be done to Section 4.2. He suggested amendments that, in his view, could help us navigate the contours of Article 88, 3 and 4. Now, so we were left in no doubt that the only way the special prosecutor could exercise prosecutorial powers was to subject the exercise of his power to the authority of the Attorney General. So you will find that in the long title of the Act, it prosecutes on the authority of the Attorney General. Then we came to Section 4.2. But what were we trying to do? We were trying to create an office out of the Attorney General's office, but insulate that office from political interference and empower the special prosecutor to go against politically exposed persons in specific offenses like corruption-related, and breaches of the Procurement Act. So to do that, we thought that the best way to insulate the office from political interference and empower the office to deal with politically exposed persons and persons in the private sector, we needed to give the office institutional independence or operational independence first. So when it picks a case and it is doing the case, no one, not even the Attorney General, can take the case away from the special prosecutor. That was the first thing. The second thing is the Attorney General doesn't determine which cases the special prosecutor must prosecute. So that comes to the fiat matter. Shouldn't determine which cases the special prosecutor should prosecute, because when the Attorney General determines the cases the special prosecutor should prosecute, he will use his fiat to control the special prosecutor. So how do you ensure that the Attorney General doesn't control the special prosecutor? 3, if the Attorney General is the person to give the special prosecutor money, he can use that leverage, that tool, to manipulate the special prosecutor. He can starve the special prosecutor of resources to be able to work. If it is pursuing a case that is not in the interest of the Attorney General. So you needed to give the special prosecutor financial independence. Now, you needed institutional independence. That yes, even though the special prosecutor has been carved out of the Attorney General's office, the Attorney General does not play any role in appointing people to that office, or in appointing, in determining the day-to-day administration of the office. Attorney General cannot do that. So that is how we sought to secure the operational independence, institutional independence, and financial independence. So you will see clearly that the structure, form, and responsiveness of the Special Prosecutor's Office is unique.
Well, the argument has always been that you cannot use, is it an inferior act to try to amend the Constitution, can you?
That's right, Lenin. No one can do that.
Okay.
You cannot even amend the Constitution surreptitiously. If you want to amend the Constitution, you must expressly say so in the constitutional instrument. So you can't amend the Constitution. So we're not seeking to amend the Constitution.
88.4, that you refer to. All offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. How did you secure that authorization for the Office of Special Prosecutor?
So I've just told you, have you read the long title of the act? Do you have the act with you?
No.
So you read the long title. So the long title subjects the authority of the Special Prosecutor, the prosecutorial power of the Special Prosecutor to the Attorney General. That's all. It recognizes Section in Article 88. And Section 4.2 of the Act 595 also subjects the power to prosecute to Article 88. Article 88 of the Constitution. Subject to Article 88 of the Constitution. So that was the way we sought to navigate the contours. So no one is in doubt that the Special Prosecutor, we didn't establish an independent Special Prosecutor. We established a Special Prosecutor who is an officer from the Department of the Attorney General's Office, but has operational independence. That's a structure. That's a structure. You understand? So we didn't establish that. We didn't seek to take away the powers of the Special Prosecutor. And that is why when people argue this way, yes, I'm not saying that the law was perfect. I mean, everybody, we inclusive, members of parliament, knew that the law would be exposed to substantial risk of scrutiny and challenges in court. We knew that. But we're using our best endeavors to ensure that we answer to the question of the time. How do you create an institution with integrity and the necessary independence to go after politically exposed persons without being politically interfered with? So we're using our best endeavors to try to answer to that vexed question of dealing with corruption.
And I understand that. In fact, I'm now looking at the act. The long title is an act to establish the Office of the Special Prosecutor as a specialized agency to investigate specific cases of alleged suspected corruption and corruption-related offenses involving public officers and politically exposed persons in the performance of their functions, as well as persons in the private sector involved in the commission of alleged or suspected corruption and corruption-related offenses. Prosecute the offenses on the authority of the Attorney General and provide for related matters. Is it? Look, the question is, when you say on the authority of the Attorney General, are you saying that every time before he goes to court, he notifies the Attorney General, secures his authority before?
Practice doesn't lend credence to that question.
Okay.
What the Attorney General does is to use an EI, executive instrument, and give the Special Prosecutor a fiat, or to give an institution that will be prosecuting on his behalf and a fiat. That's the authority. The authority in law is called the fiat. So it's not on a case-by-case basis. No, it's not so.
Does that EI exist?
Well, I don't know. Some say it exists.
But you've not seen it.
I've not cited it. And that is strictly an executive function, not so.
But Parliament passed the act, and Parliament should have ensured that
No,
EI
that's
is passed.
That's an executive action. That's not a legislative action. EI are executive instruments. They're not legislative instruments.
I see. So, to the extent that perhaps when the matter went to the High Court judge, as we have asked for that EI, if he doesn't see that EI, is the High Court judge not right to say, then you have no authority to prosecute this matter before me?
That will involve an interpretation. That will involve an interpretation. Because when you read article, you have the EI with you. No, you have the law with you now.
Yes.
So read for the benefit of your listeners, Section 4.2 of the Act.
It says, subject to Clause 4 of the Article 88 of the Constitution, the office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. So, Alhaji, the OSP takes me to court, and I raise a preliminary legal objection that the OSP has no authority to prosecute me. The person who has the authority to prosecute me is the Attorney General. The OSP says, my law says I have the authority. And then they ask the OSP, where do you derive your authority from? Because the Constitution says only the Attorney General can do it. If the OSP is unable to show that EI that you are talking about, that then see the Attorney General saying, I have given this person the authority, then would the judge not be right in applying the law to say no?
Section 4.2 again, and I'll tell you something.
Okay. 4.2 says, subject to Clause 4 of Article 88 of the Constitution, the office shall, for the purpose of the Act, be authorized by the Attorney General to initiate. Be authorized. Yes.
What rule has a special prosecutor got there?
In terms of
action.
No, they actually used to prosecute.
No, what rule? The law says the office of the Attorney General, the office shall be authorized.
Yes.
So who has the duty to perform?
That's the Attorney General.
Yeah. So why are you asking the special prosecutor?
So Alhaji, is that not where the problem is? Because then the Attorney General comes to office and says, the man who is raising the objection is right. Does that not make it easier for the judge?
What I'm saying is that, so when you read the law, it's the Attorney General that has to do it. And the law says that the law appears not to even give the Attorney General a discretion in the matter. The law doesn't give a discretion in the matter. It's a duty imposed on the Attorney General. So why are you holding the special prosecutor responsible? Oh, you don't read it. Read it once again.
No, I am not holding the special prosecutor responsible.
Yeah, so why?
I am actually holding you responsible.
Why are we not asking? Why are we not asking? Why hasn't the Attorney General given the special prosecutor authorization to prosecute? Why are we not asking that? Because the law says that he must do it.
Okay.
Why are we not asking that?
Okay. I understand your point. Thank you.
Yes.
Well, thank you. Thank you very much. Always a pleasure talking to you. Alhaji Inusah is member of Parliament for Tamale Central. I always enjoy my banter with. Thank you very much.
Tell the people why you're doing things.
But is it their problem? What does happen? It's not their problem. No, but you see, very interesting. Alhaji's point is this: that The law says the office of the special prosecutor shall be authorized by the Attorney General.
Yeah.
So the Attorney General cannot go to court and say and
has
argue any other. If immediately they are called into the matter, they should find that EI and show it to the court. It is not the job of the special prosecutor. The special prosecutor has been recruited to operate under a law. That law places a duty on the Attorney General's office to ensure that that man has the authority to go and prosecute in court. That's Alhaji's interpretation of the act.
But if the EI that we are talking about does not exist,
so the Attorney General must make sure it exists.
And so if it doesn't exist, then it means that then the special prosecutor does not have the authority to do.
And so why has the Attorney General not ensured that
And
that
until
EI
you
is
have the authority to do, you cannot do, right?
Then you see, Nancy, that's where the problem then will come in, because then people will be writing saying that then the Attorney General does not support the existence of the Office of Special Prosecutor, or is trying to do them in. Because then what the Alhaji is arguing is that the responsibility falls on the Attorney General. Not on the OSP.
But I am happy we are here. I am seriously happy we are here. Let's deal with it, because I have all along seen the tension.
Where the problem, that there was going to be a problem.
Yes. So let's deal with it now, and then we'll all be on the same, what do we call, stage. We all have an understanding where the special prosecutor is going, where Attorney General can also come in. So let's look at it. Let's deal with it now.
Andrew Appiah Dankwa is a private legal practitioner. He is the